Hi Kylie, thank you for presenting me with the opportunity to help advise one of the major firm's agricultural clients in regards to their present and future agribusiness endeavours. As you briefed me earlier, it's to my understanding the client is keen to innovate and progress with technological changes and new challenges that may arise within their chosen profession, the rice producing industry. I have some legally sound suggestions to present in this vidcast, which I think are certainly applicable and relevant to our client's industry and are of a practical sense in regards to incorporating the PPSA provisions to suit the client's business. I've kept in mind that you will be presenting this information to the client, of course. So I've kept it to relatively plain and concise language, without too many confusing terms or legal information. The PPSA was regulated to bring some clarity into the industry of creditors and to help manage those creditors in regards to security interests, which take priority over others when someone goes insolvent and receivers become involved in seizing personal property. An obvious starting point here is the PPSA. I believe the first port of call is for our client to fully understand the importance of registration in regards to their security interests. The PPR is an effective registry system, as you'd be aware, and for as little as $6.80, a business can receive cover for up to 7 years, which is really it's a small price to pay to ensure security over personal property that may be leased or sold in a number of different day-to-day transactions and commercial situations our client finds themselves in. By taking the quick and easy proactive registry steps, our client will be essentially safeguarding their property and, of course, their business. Registration is achieved on the PPSR website and involves the lodging of a financial statement detailing the client's interest in specific personal property when dealing with other parties. By achieving registration of security interests, our client is giving themselves the best chance of edging out other creditors with rivaling security interests in an insolvency situation, which could involve a number of secured creditors and will help give them a high priority interest to help ensure the client is well covered and has efficient security over all relevant personal property. Now to go on and discuss the current and future dealings our client has with other parties. Our client has instructed us they have harvesting equipment at a local business, Fix It Repairs, which is due to have some repairs carried out on that particular equipment. Now, Section 12 of the PPSA outlines to us specifically that security interests relate not only to goods, but also to performance of an obligation. Our client has developed a security interest with Fix It Repairs, and Fix It Repairs is obligated to perform the duty of repairing the harvester equipment. So that's what the facts of the case are telling us there. It is up to our client to register this security interest that it has on the property. If the interest is not secured and Fix It happens to go insolvent, the harvesting equipment owned by our client can be taken by receivers, as the harvesting equipment is on Fix It's premises. The underlying principle here is that Fix It has possession of the property. If we now look further at some other instructions provided by our client, we understand that some older harvesting equipment has been sent to Harrigan's, a local equipment dealer, and the harvesting equipment intends to be sold at that premises. This is to be regarded as a consignment. The PPSA explains that consignments are to be considered security interests whether they're commercial or not. So Harrigan's is only required to pay our client once the goods have been sold. Even though the property is possessed on the premises of Harrigan's, our client obviously seeks to retain title of ownership of that property until that's sold. That's quite obvious what a consignment is. Our client indicates they have arranged via Twitter the arrangement with Harrigan's. This puts them at great risk as they simply haven't adequately secured their property in accordance with the PPSA and the PPSR. A contract of sale or retention of title clause on its own simply isn't enough to be relied on, as it won't stack up against other creditors when it needs to be counted on when it comes to crunch time. Again, registration in this instance absolutely paramount. Our client must register their interest and make themselves a secured creditor. They need to make their interest known. Our client also has some rice stored by Sunmill at times of oversupply and when there's limited silo space. This is also a condition of consignment, I believe, as the rice is held by Sunmill but still owned by our client until sold. Our client they really need to register this interest with the PPSR also to secure their interest in the rice product. Again, this is of high importance as Sunmill has possession of the rice. The rice could be lost if our client remains unsecured and insolvency occurs. If we now look at further facts, our client has indicated to us that deals were made to secure a more permanent water access allocation for their rice growing operation. Now, the Water Act 2000 in Queensland outlines that all rights to the use and flow and control of water in Queensland are vested in the state. So that water is the form of public property possessed by the government. This does not mean the government owns the property the same way private property is owned. It simply means the state provides regulations for the use of this important resource. Public resources such as this are often under collective property ownership rather than common property due to it being tougher to regulate the use of common property. If we look at the case of Committee for the Commonwealth of Canada v Canada, it's clear that the government, as an owner of property, has the right to exclude whoever it chooses from the use of that property and from the use of that resource. They also have the power to exercise or impose conditions on parties utilising its property without limitations to charter. So, in essence, the state is in charge of that resource, hands down. Our client must be legally aware that they must comply with the rules and the regulations of the state in regards to use and procedures of use. They must be in line with the government there, and they must follow the government's provisions. So that about brings this vidcast to an end. I hope I've touched on all the important issues in regards to our client's needs and the PPSA. And both you and the client find this information and the suggestions useful and helpful for the client's continued progression in their chosen industry. If there's anything more I can do to assist you or the client any further, please don't hesitate to ask. Okay, thank you and bye for now.